Welcome to the Deep Dive. This is where we take your learning materials and really try to extract the crucial insights for you.
Exactly. And today we're diving deep into topic 3, imperative or command theories of law.
Right. These are resources made available to students by the University of London. Now, just a reminder, this deep dive is purely for educational purposes.
And it's brought to you by Sonorbit Academy Sri Lanka. We really want to wish all of you the very best of luck for your exams.
Okay, so today's focus, the imperative or command theory of law, how it emerged, specifically in England. We'll be looking at the key thinkers, Thomas Hobbes, Jeremy Bentham, and, well, especially John Austin.
And it's significant because this is widely considered the earliest modern legal theory in England, a real starting point.
So what do we got to work with? The University of London VLE materials are quite comprehensive.
They really are. We've got the table of contents, the learning outcomes, which are super helpful for guiding your study, then the core readings, Freeman chapters, that Hobbes Leviathan extract.
Many lecture descriptions too. Sample exam questions, definitely pay attention to those activities, a quiz.
And even suggestions for further reading if you want to go beyond the basics. Plenty to get our teeth into.
Absolutely. So our mission today, let's be clear. We want to get right under the skin of this command theory, understand its core ideas, its historical context.
And importantly, see the differences, the nuances between Hobbes, Bentham, and Austin. They weren't all saying exactly the same thing.
No, definitely not. We also need to weigh up the pros and cons of seeing law simply as commands from a sovereign. What does that view gain us? What does it miss?
And crucially, the goal is to get you ready to tackle potential exam questions on this topic with confidence.
All right, let's start at the beginning then. Thomas Hobbes.
Thomas Hobbes.
Okay.
So he lived 1588 to 1679, a really pivotal figure. He's seen as marking the real shift towards secular or positive theories of law, moving away from divine right ideas.
And also foundational for liberalism, which is interesting. His life context seems key too, born during the Spanish Armada scare.
You can imagine how that might focus the mind on security, on self-preservation. He was a tutor, saw knowledge as vital for, well, prolonging life.
And his famous concept, the natural condition of mankind, that war of all on all, it's incredibly striking.
It is. He argued that without a strong governing power, life would be, and this is the famous quote, solitary, poor, nasty, brutish, and short.
Let's just repeat that because it's so central. Solitary, poor, nasty, brutish, and short. Wow.
Yeah. And why? Well, you put it down to a few things. Basic equality and our ability to harm each other, and then these 3 drivers of conflict.
Competition.
Diffidence, that's like mistrust.
And glory, the desire for reputation.
Exactly. So faced with this chaotic state of nature, what's the solution? For Hobbes, it's the social contract.
Right, the idea that rational individuals would agree, essentially, to give up some of their natural freedoms.
Hand them over to a sovereign power. And in return, they get security, order, protection from that war of all on all.
He called the sovereign a mortal god. That really emphasizes the power he thought was necessary.
It does. And this leads to another crucial point for Hobbes. Law is convention. Society is an artifact.
Can you unpack that a bit? Law as convention, society as an artifact.
Sure. It means law isn't natural or divinely given. It's something humans create, something posited. Society itself isn't organic. It's constructed, deliberately built through this social contract.
Which is why he argued so strongly for an undivided sovereign authority. He was worried that divided loyalties, between the state and maybe custom or religion would just lead back to chaos.
Precisely. And that links directly to why he's seen as a forerunner, a father figure, if you like, of legal positivism.
Because law is posited by man, laid down by human
So
authority.
exactly. Law posited by man, not flowing from divine creation. That's the core idea we'll see developed.
No, it wasn't universally accepted, was it? You mentioned Sir Matthew Hale.
Right. Hale, a common law judge, pushed back. He argued for the wisdom of tradition, the common law developed over time. He was skeptical of this idea that law is just whatever the sovereign commands right now, feared it could be arbitrary.
Interesting contrast. So, for you studying the Leviathan extract, the materials pose some great questions to think about.
Yes, definitely. Like, how realistic is Hobbes's picture of human nature? Is it too bleak, or does it capture something essential?
And how well does that social contract idea actually explain the legitimacy of modern governments? Do we really consent in that way?
And the big one, should law just aim for basic survival, keeping the peace, or should it aim higher for, say, human flourishing? Good questions to mull over.
Okay, let's move forward in time then. to Jeremy Bentham.
Jeremy Bentham, 1748 to 1832, a real reformer. He really built on Hobbes's idea of legislative rationality, the idea that law should be used rationally by the government.
So not just preventing chaos, but actively shaping society for the better.
That's the idea. He was educated at Westminster, Oxford, famously critical of Blackstone's commentaries on the laws of England.
Ah, yes, his famous dismissal of natural rights.
That's nonsense on stilts.
Nonsense on stilts. You don't forget that phrase.
You don't. And his alternative was utilitarianism, the guiding principle being
The greatest happiness of the greatest number is the foundation of morals and legislation.
exactly the greatest happiness of the greatest number. That's the yardstick. Judge laws by their consequences, by how much happiness they produce overall,
He also made that really important distinction.
between what the law is and what the law ought to be.
Right, the is versus the ought. And for Bentham, utilitarianism tells us what the law ought to be.
Precisely. What the law is just descriptive. What it ought to be, that's where the principle of utility comes in to guide reform.
And his interest in rational control, the panopticon, comes to mind.
Ah, the panopticon, yes, that prison design. The central tower, the cells arranged around it, the idea of constant potential surveillance.
It's a powerful image, maybe a bit chilling. It definitely speaks to that modernist obsession with visibility, control, maybe efficiency above all else.
It certainly raises questions about power and observation, doesn't it? But it shows his drive for rational design. And interestingly, he was involved in founding University College London.
As a sort of utilitarian alternative to Oxbridge.
Kind of, yeah. More secular, more focused on useful knowledge.
Okay, so Hobbes gives us the powerful sovereign for security. Bentham gives us the rational legislator using utility. Now, John Austin. He seems to put it all together into a more sort of defined legal theory.
That's a good way to put it. John Austin, 1790 to 1859, he knew Bentham was part of that circle, the philosophical radicals.
And he became the first professor of jurisprudence at UCL, you mentioned.
Yes, a brand new post. Legal education then was very different, much more about apprenticeship. Austin studied Roman law, German civil law, trying to bring a more systematic, analytical approach to English law.
And his main goal, influenced by Hobbes, you said.
Definitely. His aim was clarity. To define positive law made by humans, and place it squarely within that political framework, a sovereign giving commands to subject.
Right. Positive law within a political framework of sovereign and subject. That's the key.
And this leads us to his absolute core concept, the one you really need to know inside out. Positive law as commands of a sovereign backed by sanctions.
Okay, let's break that down. Command, sovereign, sanctions.
Right. So first, a command. For Austin, it's not just any request. It's a signification of desire.
Okay.
But crucially, it comes with the threat of a penalty or punishment if you don't comply.
So a signification of desire with the liability of evil if not complied with. That's the definition.
That's the definition of command. And if there's a command, then the person it's directed at has a duty to obey.
Ah, so command and duty are linked.
They're correlative. Two sides of the same coin. A command implies a duty.
And if you breach that duty.
Then comes the sanction. The evil, the punishment, that will likely follow.
Okay, command, duty, sanction. Got it. What about the sovereign?
The sovereign, this is crucial too. For Austin, it's a determinate person or specific body of people, like Parliament, maybe, who receives habitual obedience from most people in the society.
Habitual obedience.
But, and this is the other key part, does not habitually obey any other human authority.
Yeah.
No higher earthly power.
Right. Receives habitual obedience from the bulk, but doesn't habitually obey anyone else. That's the sovereign.
That's Austin's sovereign. And putting it all together, positive law is simply those commands issued by that sovereign to their subjects.
Laws set by political superiors to political inferiors.
Exactly.
So what isn't positive law, according to Austin?
Good question. He makes distinctions. There are things he calls laws by close analogy. He groups these under positive morality.
Positive morality.
What's included there?
Things like rules of honor, dictates of fashion, international law, customary law, even constitutional law, in his view. They aren't commands from the sovereign backed by sanctions in the same direct way.
So social rules, basically, or rules between states. Kind of, yeah. Rules set by opinion or common agreement, not by the defined political sovereign. And then there are laws by remote analogy, metaphorical uses like the laws of physics, obviously not commands.
But what about things like custom or judge-made law? How did he fit those in? They don't look like direct commands from Parliament.
Right. His solution was to see them as tacit commands. The sovereign knows judges make law, knows customs exist, and by not overturning them, the sovereign implicitly commands them.
So the sovereign's silence, their acquiescence, makes it law.
Tacit commands affirmed by acquiescence. That was his argument. He did admit some exceptions, though, things jurisprudence studies, but that don't quite fit the command model perfectly.
Like what?
Declaratory laws, just stating what the law already is, repealing laws, canceling old laws, and imperfect laws stating a duty but with no sanction attached.
Okay. But the core is still command, sovereign, sanction. And that leads to his really famous statement.
The separation thesis, absolutely fundamental. The existence of law is one thing. Its merit or demerit is another.
Let's repeat that because it's so vital. The existence of law is one thing. Its merit or demerit is another.
Exactly. Whether a law is good or bad, just or unjust, is a separate question from whether it is a valid law according to his criteria. Command of the sovereign, habitually obeyed, etc.
This is the heart of his analytical jurisprudence, isn't it? Focusing on analyzing concepts.
Yes. He wanted to analyze the core concepts.
Uh.
Law, legal duty, legal validity. Define them clearly, scientifically, separate from moral judgments.
Which is the essence of legal positivism. Law as a scientific object of study, separate from morality.
That's it.
Now, it sounds neat, but it has faced a lot of criticism, hasn't it?
Oh, absolutely. Loads. A major one is, well, who is the sovereign in many modern complex states? It's not always easy to identify one single, unlimited, habitually obeyed entity. Think about federal systems or constitutional limits.
Good point. And what about legal continuity? When one ruler or parliament replaces another, how does the habit of obedience transfer instantly? His theory struggles there.
It does.
Yeah.
And the command model itself, critics say it doesn't really fit all laws well. What about laws that grant powers, like how to make a valid will or get married? They don't feel like commands with sanctions.
More like recipes or instructions?
Kind of, yeah. Power conferring rules. And then there's international law. Austin basically said it wasn't really a law, but positive morality, because there's no overarching global sovereign.
And H.L.A. Hart famously developed many of these criticisms, right?
Hart's critique is probably the most well-known and influential, yes. Though, interestingly, Austin's work is getting another look now.
Oh. In what way?
Well, his focus on law and power, the coercive aspect, is seen by some, like Cotterell, who you should read, as still very relevant, especially when thinking about law in, say, unstable states or situations where state power is very visible and contested.
Right. So thinking about exams, what are the key takeaways for students?
Okay, first, nail those core definitions. Command, sanction, duty, sovereign, positive law. Be able to define them in Austin's terms.
Understand the lineage, Hobbes, Bentham, Austin, but also the differences in their approaches and aims.
Definitely. And be ready to discuss the pros and cons of the command theory. What are its advantages? Maybe clarity, certainty about the source of law.
And the disadvantages. We just listed a few: difficulty finding the sovereign, not explaining all types of law well, ignoring the non-coercive side of law.
Exactly. Think about the sample exam questions provided. They often ask you to critically evaluate Austin or compare these thinkers. Consider Cotterell's reading linking Austin to power.
And always remember the context. When were they writing? What problems were they trying to solve?
Absolutely crucial. And review those learning outcomes from the module guide. Can you actually do what they ask? Can you critically discuss positivism? Analyze the command idea. Understand Austin's context and Hart's criticisms.
Use the sample questions to test yourself. Can you build an argument focusing on just one thinker, as one of the activities suggests?
That's a great way to prepare.
Okay, so let's try and wrap this up. The imperative or command theory, especially Austin's version, it gives us this foundational picture of legal positivism.
Yeah, law as commands, issued by a sovereign, backed by state power, by sanctions. That's the basic model.
But as we've seen, it's not without its problems and critics.
Definitely not. And if you want to explore those nuances, the criticisms, the defenses, check out that further reading list, Austin's own work, plus scholars like Cotterell, Dworkin, Hart, Halpin, Schauer. Lots of different perspectives there.
Okay, so here's a final thought for you to take away and ponder. We've talked a lot about the criticisms, the sovereign, the command model not fitting everything. So thinking about law today, in our complex world with international courts, human rights norms, diverse legal rules, how much does focusing on command and sovereign actually help our understanding? And where might it actually hinder it?
A very relevant question to consider.
Indeed. Well, that's all we have time for on this deep dive. Good luck with your continued studies.